The next case is In Re Long.
Good morning. May it please the court, my name is Keri Middleditch, and I'm here on behalf of the appellant petitioner, Tanya Long. Today I'm asking this court to grant the application filed on behalf of the appellant and reinstate the trial court's findings, indicating that jurisdiction was appropriate and was rightfully assumed pursuant to MCL 712A.2b2, as well as 712A.2b6. And the trial court's reliance on In Re LE was not misplaced. Jurisdiction was properly asserted pursuant to MCL 712A.2b2 because in many instances like this case, the court often asserts jurisdiction when a child is not found within the home of the parent at that time. One of the things that I talked about in the supplemental brief that I filed with this court was the sort of regular workings of neglect petitions. When petitions are filed to a couple of things, to seek jurisdiction over the children at issue, or termination of parental rights, or in some instances to try to rehabilitate the family. In many of those instances, the children have already been removed from the home. In fact, in termination petitions, the vast majority of termination petitions come from a supplemental petition, where children are already in the jurisdiction of the court, and it's actually the trial court that orders that a supplemental petition be filed seeking termination of parental rights. When that happens, the court notably already has jurisdiction, but the children are also not in the care of their parents. But in other instances where the petitioner, usually the Department of Human Services or the Attorney General's office acting on their behalf, or the prosecutor's office acting on their behalf, if there is an initial petition seeking termination of parental rights, usually there is some really grave circumstances that have transpired. Maybe it's physical abuse or sexual abuse or something of that nature, where the child has been removed from their home immediately on an emergency removal basis. When that happens and that termination petition is filed, by the time the court does its inquiry, the children are already out of their parents' home or their custodian's home. And so when the court starts to look at the home or environment, by reason of depravity, criminality, etc., much as the statute tells us, the children aren't in the care of their parents anyway. They're already in protective custody, whether that's with another family member or foster care placement or what have you. And again, most petitions that are filed really happen because there are significant circumstances, much like there are here. Here, when we start to look at the home or environment of respondent father, we see that it is less than ideal. Simply put, he has a criminal history that is extensive, that include both convictions and contact with the police. Violent offenses, drug offenses, offenses that actually were against the mother of the child, and she testified about that extensively at the trial. In fact, some of his offenses involved minors. The whole reason that he's in prison as I stand here today is because he was accepting earnings of a prostitute, and that prostitute was a minor, in fact, a high school student. Much of the facts about respondent father's history are actually not in dispute here. That what is in dispute is how we apply the law. But the facts, by and large, were not disputed at trial. In addition to the domestic violence against the mother, he also had home invasion he was actually on probation for home invasion when he picked up the accepting the earnings of a prostitute. He admitted that he could spend upwards of 35 years in prison, and his first chance of parole is actually in February of 2021.
Counsel, am I correct, though, that at the time, this isn't one of the situations in which you referenced that there was an immediate removal from the home? Your
That's
client
correct.
was the child's guardian.
That's right.
For how long was the child in your client's home or environment at the time that the petition was then filed to terminate?
So the child was born in 2012, and my client obtained guardianship in 2012. The petition seeking termination of his parental rights was in 2016.
So for 4 years, the child's home was with the guardian.
That's right.
And that home was not, on the part of the respondent father, was not unfit, nor was his environment unfit because of the respondent father, right? I mean, the father, did he have an environment with the child?
So the child had pretty limited contact with respondent father. And admittedly, he's been in prison, I think, since 2014. So I don't dispute that there are no allegations against my client that her home or environment is unfit. The argument I'm making is that the home or environment, if the child were placed with father, which is an impossibility at this point because he's in the Michigan Department of Corrections, would be unfit. And
Well, then why would we look at it from that perspective? If that's not his current home and it's not likely to be his home or environment?
Well, because the whole idea of a child protection case is to do just that, to protect a child. And in many instances, and I would sort of point back to the statutes that we have here. For instance, the statute does not preclude 712A.2b2, which we're talking about now, by reason of criminality, depravity, neglect, the home or environment is an unfit place for the child. When you go back and look at that, it doesn't say if the child's in a guardianship, you can't seek jurisdiction this way. We have to look at what the home or environment would be with that parent. And frankly, there's a number of cases, and I referenced them in the brief, that are unpublished, admittedly, where the Court of Appeals actually did assert jurisdiction when a child was already in guardianship or in the care of somebody else, whether it was foster care or another relative or what have you. But it is important. The point of the child protection statute is to protect the child. And I certainly understand, as I stand here today before all of you, that this is always a balancing test, right? We look at what are the rights of the father, what are the rights of the child, and how do we balance that in the grand scheme of our public policy concerns
Counsel,
and doing the right
the
thing.
termination statute doesn't ask us to speculate about how the child would thrive or not thrive if he or she were with the parent. It asks an actual factual question about how that child has thrived in the home or environment in which he or she's been living. Isn't that right?
I don't believe so.
Well, I'm looking at the language. Where would I be mistaken when I look at the first word in 712A.2b2, which says whose home? Whose clearly refers to the child, does it not?
Whose home, yes, or environment, And my argument to you, Justice Markman, is that the environment that father did briefly provide or could provide would be full of neglect and criminality and does not
We're
serve this child.
hypothesizing about that. You may well be right about that. Wouldn't the adoption code be the better venue within which to debate and discuss and address those issues?
Respectfully, no. There's really two, there are two places under Michigan jurisprudence where we can terminate parental rights voluntarily, the juvenile code and the adoption code. But under the adoption code, really, there's no direct placement of the child here, so really we would be left with a step-parent adoption, and we don't have those circumstances here. So what we have here is a child who is in guardianship, who is, I would say, thankfully able to avoid having to go through child protective services and the foster care placement system, et cetera, and be in the loving home of his maternal grandmother, where he's had the good fortune of landing since he was an infant. But the reality is, and there are a number of cases, and one of them is the In Re MU, where in that case, and it's talked about both in my brief as well as that of respondent fathers, where we look at the present tense, just what you're asking me about.
Is your response to me that no, you're not asking us to speculate in any way, but the word environment in particular is a broader term, or at least a distinctive term from home, and that's the kind of venue we need to look to here.
I do
Because
think-
clearly the child has not lived with the father in the father's home in any way. So it's only, if I'm interpreting it correctly, an argument on your part that somehow the environment is a more flexible, a more broad-based term that allows you to consider the father's conduct in some way. Is that right?
Yes, I agree, and I would just say, I don't think we have to speculate. I think the facts are pretty clear, that he is a convicted criminal, he's had a lot of contact, and I don't think that requires speculation. He is in the Michigan Department of Corrections. He admitted that he never had a job, that he didn't have the financial means to pay for this child, that he never contributed one thing to this child. So I don't think that requires speculation, it just requires us to take a look at the facts that were already
It does
admitted.
require speculation if the term is home, because whatever we do know about the father, we know nothing about the child having lived in the same home as the father, because that never took place.
No, you are correct. And I will say there was very limited testimony at the trial where he being respondent father, spent a few days with the child in a hotel. And I agree with you, they never shared a home. But I do think the statute absolutely says home or environment, and the environment provided by father.
So what does environment mean to you? Home or environment does, of course, seem to suggest that environment is a distinctive term in some respect, and arguably it's a little bit more flexible and broad. Could you make that argument?
Yeah, I do think that you look at the current circumstances, or you look at the ability of the parent to provide the upbringing that we would want for, frankly, every child. And the reality is that respondent father has been, frankly, incapable and demonstrated himself to be completely unwilling to do those things that is necessary for a child.
Counsel, can I ask you, jumping to subsection 6, and, the Court of Appeals holding that a putative father is not a parent as defined under the Act. But respondent has been determined to be the father, and therefore a parent, since July or August of 2017, correct? Is that when his
Yes, you're talking about
paternity
under
was
2B6.
established?
Yes, and
Yes,
paternity was
under
established in the
subsection
context.
6.
Yeah.
So while at the time the petition was filed, and he did not have 2 years of not supporting the child as a putative father, we are now 2 years since he has been established a father, right? And the requirement that in those 2 years, presumably, that he needed to be supporting this child. That now applies to him, correct? But perhaps not at the time the petition was filed.
At the time the petition filed, you are correct, he was absolutely putative. And quite candidly, it was through no action of respondent father that the paternity got established. In fact, he testified both by phone and in person to the trial court that he didn't have the means to pay for the paternity testing, although indicated he wanted to. So frankly, it was the county that paid for it. It was, frankly, me that arranged for the DNA testing to happen at the Michigan Department of Corrections at the court's direction. When he established his...
But what Justice Kavanaugh wants to know is, at this point, we have the 2 years, we have the 2-year period established since he was determined a father. So why do we need to stretch the statute,
When he was a putative father.
when you have other ways to do it? Or why couldn't, what was wrong with the adoption code, which addresses termination rights of putative fathers? That would have been a way to proceed even though he was not yet a legal father, correct?
Well, there wasn't a direct placement to get into, I think, Section 39, et cetera. What I would say to answer, I think, the first part of your question, which I believe is really about could we do something now if 2 years have passed? And the answer is I don't believe so. Because now what has happened is, because the Court of Appeals overturned and reversed what happened at the trial court, they being the trial court, issued an order to try to resume contact, or to start contact, because quite frankly, this child would not know respondent father at all. He hasn't seen him since those few days as an infant. And that has been supposed to be happening through the child's psychologist or therapist. And at this point, the therapist has said that that's not happened. So I don't think that I could come to court with clean hands and say he hasn't had contact with this child for 2 years, because it isn't for lack. Admittedly, he has asked for contact. We've been to court a number of times, and it's in the lower court record where he's asked. So I don't think I could do that.
Under
simply
sub
put.
6, he would have to establish, or a basis for jurisdiction would be that the father for the last 2 years hasn't provided regular and substantial support.
That's correct, but if I can make one prong, I'm simply stating to the court, I don't think I could meet the burden on the other. He's asking to have contact. The court is trying to do that in the safest way possible at the trial court level. So I'm saying that's not an either or. I have to show both of those prongs, and I'm saying, to Justice McCormick's point, I don't think I can come back and now say 2 years later, okay, now I have the 2 years under my belt, and say your rights can be terminated, because he has been asking for contact, and frankly, it's the court who's slowing that pace, frankly, in the best interest of the child, given the testimony that has come in so far, given the circumstances. So I don't think that's at all a plausible solution. Moving forward with
But he had
regard...
no obligations essentially during the 2 years prior to the filing of the suit. He was a putative father at the time of the filing, so in the 2 years preceding that filing, he was putative, and he didn't have the same obligations at that time, so we really can't hold that against him, can we?
I think you can. I am particularly troubled by the fact that he used the paternity as both the sword and the shield. All of these years, this child, at the time that we filed this petition, he says, I'm sorry, I have no obligation, and he literally did nothing. He actually signed an acknowledgement of paternity in a Wayne County matter that happened prior to me initiating this petition. But Wayne County dismissed this case, and when I found the file, I saw that he had signed an acknowledgement of paternity saying, yes, Isaiah is my father, but he never carried through with
But
that.
that's the great thing about the adoption code again. I mean, you can air out whether he was a do-nothing father or he was a contributing father.
Well, but not exactly. So now he gets the benefit of not doing anything and said, sorry, I didn't establish paternity. I have no financial obligation. And now at the same time that paternity has been established, he says, sorry, you haven't given me my 2 years. While I respect that he has rights, we also have to balance the rights of a child under the Child Protection Code and serve their best interest, who is now left in limbo without any sort of permanent plan or consistency or stability going forward. I believe my time has expired.
The child is not entirely at sea. The child is living with your client, right?
There's no doubt that the child is doing very well, thanks to the significant efforts of my
That was my
client.
understanding.
Thank you, counsel.
Thank you.
Good morning, Chief Justice and Justices. My name is Nancy Miller, and I'm here on behalf of the appellee, who is the father of the child, Jerome Hester. Today, we would ask the court to deny leave to appeal. First of all, with regard to MCL 712A.2b2, I don't believe that the Court of Appeals erred at all in reversing the trial court. The statute specifically says that a trial court may take jurisdiction in proceedings concerning a juvenile under the age of 18 years found within the county whose home or environment by reason of neglect, depravity, criminality. The statute specifically is referencing the home or environment of the juvenile. And in this case, the home or environment is with his guardian. It has never been with the father. And there have been no allegations that the guardian's home is unfit for the child. We have to have some sort of common sense here. Obviously, we're not looking at the home of a temporary placement where a child has been removed and placed with a foster family or with a relative and say, well, on the day the petition was filed, this child was in a foster home and we should look to that residence. No, we're looking at the residence of where the child was placed. That allegedly gives rise to the issue of whether the home was unfit. But again, in this home, there's been no allegation that the guardian's home was unfit for the child in any way. I believe the child was either 2 weeks or 2 months old when he began living with his maternal grandmother. And Mr. Hester has never said, as soon as I get out of prison, I'm going to go and take this child. He has indicated on the record that the guardian's home is appropriate, and he thinks that maternal grandmother is doing a wonderful job. He has just indicated that he wants to be a part of his child's life. In Ray Curry is a case where both parents became incarcerated.
How much of a part of the life does he want to be a part of? Like when you said he wants to be a part of his life, like what does that mean?
Well, one of the main issues is the child is biracial, and he wants the child to get to know him and his family, to understand that part of his heritage. He has indicated that so long as he is incarcerated, he'd like to be able to send the child cards and letters and perhaps have telephone conversations with him. He wants to be able to, if possible, send him birthday presents or Christmas presents. So he is not at all saying that he wants to step in and disrupt this child's life and remove him from his maternal grandmother.
I see. What would the limitations be? I mean, cards, presents, phone calls, is that the extent of it? I'm just trying to understand what the degree of participation is that you're looking for.
I believe that there's been some discussion at the trial court level, which I'm not involved in, of perhaps having visits at the jail, or at the prison, excuse me.
Okay, thank you.
In Ray Curry, the parents were both incarcerated, and they placed the children with maternal and paternal grandmothers. They kind of shared custody of the children. And a petition was filed to terminate their parental rights, and the court stated there's no showing that the home in which the children are living right now, which is the grandmother's homes, were unfit. And the simple status of the parents being criminals did not make the home unfit. You had to look at the effect that the criminality had on the children. And in this case, Mr. Hester's criminality had no effect on this child. The child doesn't know him. He doesn't know the child.
Doesn't that have an effect?
How so?
Well, he doesn't know him.
That's true. The cases that we're looking at, there are situations like in Re-MU where the father was suspected of having something to do with the murder of the child's
see.
mother. Or there's the case of in Ray.
You're saying the effect
In Ray
has to
Sessions.
be, your argument is the effect has to be completely direct. It has to be,
Well, it has to be more direct.
I see.
In Ray Sessions, there was a history of domestic violence where the father had actually attacked the mother while she was holding the
Right,
child.
okay.
In Ray Houlihan, where the father was convicted of murdering the child's mother. The loss of a parent obviously has a big effect on a child.
So the lack of being a parent due to crime, your argument would be, is not implicated.
No, because we have, for example, in Ray Mason, where the parent, even though he's incarcerated,
Right, okay.
doesn't necessarily lead to
Right.
termination.
Okay. Thank you.
Counsel, can you help me understand the definition of parent in the statute, in particular
Yes.
under B6? The Court of Appeals looked to the court rule definition of the term, and I guess I'm wondering if that's the correct way to interpret that term, or if we should interpret it like we interpret, I guess the question is, why did they do that? And it's certainly not the default way that we interpret statutes, by looking at definitions in other places.
Well, in the arena of child abuse and neglect law, child protection law, they look at a parent as being the legal parent, having either established parentage by marriage, or by court order, or by affidavit of parentage. And I believe that is the definition that we've been looking at in this case.
It's possible that a broader definition of parent could apply, right? Somebody's biological parent, for example,
Sure.
might come within that, if it's a word that we're going to interpret according to its ordinary usage.
Yes, Your Honor.
Why shouldn't I think that the legislature intended the term to have a broad meaning in the statute? It's not defined in the statute, and as far as I could tell, the statute doesn't tell us to look to the court rules to define the terms. And in fact, the court rules themselves don't purport to define the term for purposes of the statute, only for procedures under the statute, but they don't directly relate to this term, nor do I think the court rules would have the power to do that, to change the substantive law.
The courts have always looked at whether or not there is a legal basis for paternity in these child protection cases. And if the father has not established paternity in one of those three methods, he's a putative father, and there's no rights to terminate. I hope I've answered your question.
Well,
Counsel, if you're correct that the court can't directly consider the fitness of the respondent parent's home or environment under this law unless the child actually resides with the parent, isn't that tantamount to saying that the child has to be exposed to a bad parent and placed in the bad parent's home or in the bad parent's environment before the court can acquire jurisdiction over the child under this statute? Isn't that kind of an odd and anomalous result?
I understand what you're saying, and no, the child does not have to reside with that parent and be subjected to an unfit environment. If, for example,
So how do we assess the likely conduct of the parent?
well, it depends on how the criminality affects, the depravity, the lack of morality, how it affects the child. For example, in the Villanueva case, the child had never lived with the father, and he had an extensive criminal history, but he had also had 5 prior terminations of parental rights. So it wasn't just his criminality that led to his determination of his parental rights. It was also the fact that he had previously had his rights terminated 5 other children. So looking at the effect that the criminality or the depravity would have on a child.
I understand the arguments, and you're doing an excellent job, but I guess what I'm grappling with as I kind of go through this case is, how is this really in the best interest of the child here?
Well, Your Honor, I'm a court-appointed attorney.
Right, I understand.
And I often am appointed to be the lawyer guardian ad litem.
Right,
And so I see all sides. I'm a grandmother,
right.
and my heart goes out to the maternal grandmother here, because I lived with my grandchild for the first 6 years of her life. In this case, I'm appointed to represent the rights of the father, and he does have certain due process rights.
So am I
And
supposed to look,
also-
I guess my question is, so your argument is, I'm supposed to look at this exclusively from what the father wants?
No, I'm asking you to look at it in what the statute specifically states
Right,
and
I
apply
understand.
the facts to the statute.
Okay.
And at this point in time, I don't believe that jurisdiction was appropriate under the statute applying the facts to the law.
Okay, I understand. Yeah, it's a tough question. I appreciate your answer.
Moving on to 712A.2B6, when the juvenile's in a guardianship, to summarize, whether the parent who has the ability to support or assist in supporting the juvenile does so, and whether the parent having the ability to visit or communicate with the child does so for the 2 years prior. And Ms. Middleditch already discussed the argument about, well, he wasn't the parent, the legal parent of the child, so we should not consider his actions for the 2 years prior. Even if, assuming arguendo, that we could consider him to be the parent and be subject to the 2-year requirement, he was incarcerated for the 2 years prior to the filing of the petition. He testified he made very minimal amount of money. He did not have any money to assist in supporting the juvenile, and he also did not have the ability to visit or contact. He couldn't reach the child. He had testified he attempted to reach the mother and the maternal grandmother, and he was not successful in contacting them. This leads us into N. Re LE. And obviously, N. Re LE can be distinguished because it dealt with termination, the termination prong of the statutes, and not the jurisdictional prong. However, obviously, it's in the best interest of society for parents to step forward and take care of their children. But in Ray Ali, it's almost, is it reasonable for the father to have believed he was the father, the biological parent of the child, and applying the facts of each case to that issue. In all of the cases that were cited, the unpublished cases, in each one of them, the father was like, I'm the father, I want to take care of my child, and then they didn't do it. In this case, Mr. Hester tried to find out if he was the father. He got different stories. Mom testified, I believe, in 3 different areas on the record, that it could be Mr. Hester or it could be a man that she thought was named William. And she wasn't real clear with Dad. She moved around a lot. Both mom and maternal grandmother testified that they didn't want anything to do with Mr. Hester. They weren't going to return his text messages. They didn't want him to see the child. Prior to him becoming incarcerated, he did try to proceed with a paternity case to find out if he was the father. He wanted to have a DNA test done. So I believe in this case, applying the facts to Ray Ali, the trial court erred and the Court of Appeals was correct in reversing, because I don't believe it was reasonable for Mr. Hester to have had that kind of certainty that he was the biological of the child,
When was your
biological father of the child.
When was your client incarcerated?
I believe 2014.
So 2 years before the petition was filed?
Yes,
Was he incarcerated for that entire period?
yes.
I see no further questions. Thank you, counsel.
Okay, thank you.
Case will be submitted.